Good afternoon, one and all. Recently, the Jharkhand High Court dealt with a very important question as regards claim of refund under Section 142, Clause 3. Various taxpayers have been claiming refund of such credits which they could not carry forward due to some reason under GST regime. This judgment will hold relevance for times to come as regards the fate of those credits are concerned. Quickly moving on to the facts of the case, the petitioner procured certain inputs from outside India. During the course of the import, it also received certain port services from Kolkata Port Trust. The Kolkata Port Trust raised an invoice along with service tax on 23rd of May 2017. Thereafter, the petitioner filed the ER1 return on 10th July 2017. It did not include the invoice to claim the credit in ER1. It also revised this return on 31st July, but that credit of that invoice of port services were not availed as such. Then the petitioner received the original invoice only in September 2017. Thereafter, it filed service tax return and claimed the credit thereon. Since by then the petitioner had already carried forward all its credit under GST Tran 1 form to GST regime, did not have any other option but to file a refund under Section 142 Clause 3. In all this while the last date of Tran 1 was only due on 27th of December 2017, but the petitioner did not file or revise the Tran 1 despite there being a specific enabling provision. The refund was presented to the adjudicating authority. The adjudicating authority issued a show cause notice. That show cause notice proposed denial of refund claim. Finally, an order was passed, which was appealed against, and even in the appeal, the refund was denied. Therefore, having left with no other remedy, it went on to the High Court under a writ petition. Before the High Court, the basic question that came into consideration was whether such credits which have not been carried forward under GST regime through Tran 1 form can be claimed as refund under Section 142 Clause 3, whether 142 Clause 3 becomes any enabling provision to allow such Cenvat credit as refund in cash. With this factual background, we move on to the ruling of the case that was held by the Jharkhand High Court. The Jharkhand High Court took note of the transitional provisions available under the GST Act, or that is CGST Act, and it held that refund is a statutory right and not constitutional or fundamental right. That is to say that there is no provision which is providing for any refund of such credits which could not be carried forward under GST regime. Secondly, the right to refund crystallizes only when the parent statute, either the CGST Act or the Excise Act or the Finance Act that provided for provisions relating to service tax, is having any statutory provision or substantive provision allowing such refund, which is absent in the present case. Failure to follow a procedure that was prescribed under Section 140 cannot revive their right to claim refund under Section 142 Clause 3. Thereafter, refund under Section 142 Clause 3 can be claimed only if a right to refund existed under erstwhile law. So Section 142 Clause 3 essentially does not enable refund of such credits which have not been carried forward under GST regime, but it only provides for a mechanism that the refund will be dealt only in terms of the erstwhile provisions. If the erstwhile provision allowed or entitled the refund of such credits which have not been carried forward, then only this refund could be granted. Otherwise, the refund cannot be granted. Thus, no such right to refund existed under Section 11B of the Excise Act, and therefore the petitioner in this case was not entitled to any refund. Further, Section 142 Clause 3 does not create any new right to the taxpayer to claim such credits which have not been carried forward or which have remained to be carried forward for some reason. And therefore, the cash refund which the petitioner was seeking was not allowed to them. In our view, the judgment is correct on law and facts. One important highlight here is that Rule 15 of the Cenvat Credit Rules 2017 provided for a provision where if the credit is not getting carried forward under GST regime through Tran 1 form, it is bound to lapse. Secondly, and most importantly, the provision has not been dealt upon by the Jharkhand High Court at all. One of the important aspects to deal with here is that CSTAT has been allowing refund under Section 142 Clause 3 of such credits which could not be carried forward under GST regime. This includes granting of refund under Section 142 Clause 3 of education cess, secondary higher education cess, and Krishi Kalyan cess, and various other cesses. However, the judgment can be distinguished for such cases where the erstwhile taxes are being paid out of an inquiry or an investigation being conducted now, that is, when the GST regime has already come up. as in the present case, the taxes, etc., were all paid prior to the implementation of GST, and the taxpayer had ample time to carry it forward under GST regime, that is till 27th of December. That's all from our side. Stay tuned for other updates.